Welcome, friend. This Nani Palkiwala Jayanti series part 3. So we have already completed most landmark and prominent judgment of the land, that is Keshwananda Bharati, which creates a doctrine of basic structure. And due to that particular doctrine, we maintain our constitutionality, we maintain our integrity, we maintain our fundamental all rights intact, and Parliament can change the constitution, including part 3. But Parliament cannot change the basic structure of constitution. And what is exactly basic structure? So 12 points which Nani Palkiwala argued in that Keshwananda Bharati case, we have seen already in past 2 parts, part 1 and part 2. And so many paras, so many citations of foreign Supreme Courts, USA, Australia, and Canada, all other Ceylon, all other Supreme Court citation also he have given, UK also he have given. So we will see, we have already seen that. Today, we are moving towards our part 3, and that is Indira Gandhi Nehru versus Raj Narayan. This case was decided by Supreme Court in 1975. So what is this case and what was Nani Palkiwala's, my guru Nani Palkiwala's contribution in this landmark judgment? So let me tell you first some features of Nani Palkiwala's contribution in this judgment. Nani Palkiwala was a prominent Indian jurist, lawyer, and constitutional expert, known for his eloquent advocacy and deep knowledge of law. His contribution to the landmark case of Indira Nehru-Gandhi versus Raj Narayan in 1975 is particularly noteworthy. Background of this case. The case arose from the 1971 Lok Sabha elections, in which Raj Narayan challenged the election of Indira Gandhi, who was then the Prime Minister of India. Narayan accused Mrs. Gandhi of electoral malpractice, including the use of government machinery and other irregularities to ensure her victory in the elections. Palkiwala's role. 1. Legal representation. Nani Palkiwala served as a lawyer for Raj Narayan. His legal prowess was instrumental in presenting the case against Gandhi. Palkiwala's argument centered around the violation of electoral laws and emphasized the significance of free and fair elections as a cornerstone of democracy. This is very, very, very great thing, friends. Second, constitutional arguments. Palkiwala's approach highlighted constitutional principles, particularly those enshrined in the Constitution regarding the integrity of the electoral process. He argued that Indira Gandhi's election involved corrupt practices and that undermined the democratic framework. Eloquent advocacy. Palkiwala was known for his persuasive and articulate courtroom presence. Very nice line. Palkiwala was known for his persuasive and articulate courtroom presence and practice. His ability to distill complex legal issues into clear and compelling arguments resonated with the judge and contributed to the case significance. 4. Judgment. The Allahabad High Court ruled in favor of Raj Narayan in June 1975, invalidating Indira Gandhi's election on the ground of electoral malpractice. The judgment led to whispered political ramification, and eventually Indira Gandhi declared a state of emergency in India shortly after that. Impact on Indian law and politics. Palkhiwala's involvement in this case had far-reaching implications not only for Indian electoral law, but also for the balance of power between the judiciary and the executive. His argument laid the groundwork for a more robust judicial scrutiny of electoral practices in India. The case remains a pivotal moment in India's legal and political history. Palkhiwala is remembered as a keen advocate for civil liberties and the rule of law, and his contributions during this case solidified his status as one of the India's great legal minds. Friends, Palkhiwala was acted in this case against Indira Gandhi. He was a lawyer of the Raj Narayan. So opposing any case against that time particular Prime Minister is a great thing. And this is a landmark judgment. And after that, Indira Gandhi has to impose the emergency for maintaining her chair. And she has done so many things up in the emergency. So all history well known to you. Now we will see how and what type of contribution Nani Palkhiwala has given in this landmark judgment. Friends, this case was in appeal, civil appeal number 887 of 1975 and civil miscellaneous petition number 3557 of 1975. This case was decided on 24/6/1975. The cause title of this case is Indira Nehru-Gandhi versus Raj Narayan and others. This you know that in the month of June, Supreme Court have the holidays, and this case decided on 24th June. So this case was decided by holiday court. In holiday court, nowadays holiday court have a 2-bench, 3-bench, but in that era, holiday court have single bench. And single bench judge also deciding case in a very, very brilliant manner. So honorable justice of this particular case is V.K. Krishna Iyer, judge. Counsels, appellate petitioner, plaintiff N.A. Palkhiwala and J.B. Dada Chandji, advocate for respondent, defendant P. Goyal. So Nani Palkhiwala was acted here as a lead counsel. Relevant section which is very important in this case is Representation of the People Act 1951, section 123. Friends, you will find my small video on YouTube on Representation of People Act 1951. And in the future, sometime near any election, when hot climate is there of election, I will take 1-2 hours larger program on Nani Palkhiwala platform so that we can discuss this Act, Representation of People Act 1951 in detail. But small video you can watch, which is for the public at large general. Many of my public large that judgments, that videos are in Hindi and English combined languages. But this specific series is for the legal luminaries, law students, law advocates, judges, and for all these peoples to remember the contribution of legend Nani Palkhiwala. And we are celebrating on 16th January 2025 Nani Palkhiwala's 105th birth anniversary, that is Jayanti. And on this occasion, we are going to conduct a big physical program on 16th January in Krishna Memon Hall, opposite Supreme Court, D Gate. But before that, 7 days, we are conducting this webinar on his contributing judgments in India's legal history. So, friends, acts and orders which involved in this case was Article 101 of Constitution of India, Article 133, Article 136, Article 74, Article 75, Article 78, Article 88, Representation of People's Act, Section 100, Section 106, Section 107, Section 116A, Section 116A4, Section 116B1, Section 116B2, Section 123, Section 86, Section 8A, Section 98, and Section 99, all these section of Representation of the People Act 1951. If you want to get mastery on election petitions, election matters, then you have to give proper attention towards this Representation of People Act 1951 and the landmark cases. Case note: civil power to grant stay. Appellant moved Supreme Court challenging unseating verdict against her by High Court. Absolute stay of judgment of High Court was also sought. Respondent opposed grant of stay. Observed that power of court to grant stay is discretionary and is to be exercised judicially. Very best line. Power of court to grant stay is discretionary. Discretion. They have the discretion to decide the stay and is to be exercised judicially by applying judicial mind, not by applying emotions. Operation of order of High Court stayed and applied and appellant allowed to remain a member of Lok Sabha for all purposes. So this is only stay order case. Okay. Order. What Justice Krishna Iyer says: right at the beginning, I must record appreciation of valuable assistance given by counsel on both sides to the court in clarifying the tweets aspects and unraveling the latent facets of what views in typically isolated legal perspective, unturned to the national wavelength and unclouded by the dust storms of politics in a dumb drum case, having regard to the perseus environs and mounting tensions surrounding the event following upon the judgment of the Allahabad High Court, it must be stated to the credit of Sri Palkhiwala and Sri Shanti Bhushan that in their submissions, they have shown how sound and fury only help thought the thought ways of law and extra legal tumult can be walled off from the court hall. The argument have been largely legal and their merits have to be vetted in judicial scales. High-level English is used by Krishna here. Judges can use such type of English in their judgment because we lawyer and all citizen, we have to get it, understand whether their language is understandable or not. We have to get understand. But as a lawyer, we should not use such type of language while we are arguing in the court. Our language should be very simple and very lucid language. We can use the difficult word also, but simultaneously we can use a substitute word also after that difficult also, because all judges are not of that category. When you are arguing as a judge, as an advocate there, many judges are from vernacular languages and with their great efforts, great perseverance in the field of justice, they reached up to Supreme Court. So while arguing Supreme Court, use very lucid, lubricative language, understandable language, and you can use more difficult word also, but use substitute word for that also. But judges can use whatever language they want. What perhaps in a certain view are not strictly pertinent to the state proceedings have, however, been adverted to and at the bar eventually and understandably, but within marginal limits, if I may say so, because the proceedings in the halls of justice must be informed to some extent by great variety, that the broad sweep of human history is guided by sociological forces beyond the ken of the noisy hour or the quick of legal nicety. Life is larger than law. Now I proceed to discuss the merits of the matter. So this is the opening in the judgment of Justice Krishna Iyer. Now I will show you the Nani Palkhiwala's contribution in this judgment. So at one place, on page number 3 of that judgment and para 4, after near about 10 to 15 lines. Nevertheless, Sri Palkhiwala has placed before me the propriety and urgency of the court taking into consideration the national situation even while exercising its discretionary power. As a counterweight to this submission, Sri Shanti Bhushan has claimed that no republic can surrender its democracy destiny to a single soul without being guilty of overpowering the parliamentary process by a personality cult. This brings to the fore as activist interrogation about the cognoscibility of such consideration by a court. Do the judicial process and its traditional methodology sometimes make the judicature took architect with eyes open on law and closed on society, forgetting the integral yoga of loga and society? If national crisis and democratic considerations and not mere balance of convenience and interest of justice were to be major inputs in the judges' exercise of discretion. Systematic changes and shifts in judicial attitudes may perhaps be needed. Sitting in time our forensic surroundings, I am constrained to judge the issues before me by canons sanctified by the usage of this court. Next, one more para I want to highlight for Nani Palkewala's contribution in the judgment. Para number 8 on page number 4. Para number 6 on page number 4. On page number 4, last 3 lines. Para 6. Sri Palkewala for the petitioner contended that unconditional stay was appropriate and essential because A, it was sanctioned by some precedent. B, there were momentous consequences, disturbances to the country if anything less than a total suspension of the order under appeal were made. C, the adverse holding of the High Court on 2 counts hardly exceeded, even on its face, technical violation unworthy of being visited with an ad interim embargo on Parliament's membership during the pendency of appeal, apart from being pulpily perceived. And D, the nation was solidly behind the petitioner as a prime minister. Minimal justice, public interest, and balance of convenience conquered in his favor. Sri Shanti Bhushan, on the contrary, joined issue on these pleas and asserted that the appellant must be treated like any other party. B, that an absolute stay was unprecedented. C, that the democratic process would take care of itself even if the petitioner stepped aside for a while. So friends, Shanti Bhushan ji was arguing on behalf of Raj Narayan in this case. And Nani Palkewala was arguing on behalf of appellant, means Indira Gandhi in this case. Earlier, what I have said, that is in Keshwananda Bharati case, Nani Palkewala argued on behalf of the petitioner. That means Keshwananda Bharati and against the government. So in that particular case, he was against the government, that means against the prime minister and against the parliament. But in this case, he acted on behalf of appellate. So he is trying to pursue, keep such type of prominent place person, if even though he loses the case, but during this period, this vacation period, this is the hearing period, stay, there should be a stay, and that particular lady should allow to work as a member of parliament. Shanti Bhushan ji tried to say that no need, all are equal before law. The corrupt practices were corrupt in law and fact, fully proved and could not be glowed over by the court of law as a technical and alleged solid support by party. Minions meant little since a similar phenomena could be organized by any stand in top office, and rule of law cannot be drawn by the drums and sounds of numbers. In his submission, public interest and balance of convenience, as also justice to the High Court judgment, demanded that an illegally elected member did not continue longer as a prime minister under the umbrella of a stay or umbrella of stay order from this court without jeopardizing the credibility of the countries abroad. Sri Palkhiwala assailed in his opening submission. This is a para 7 on page number 5. Sri Palkhiwala assailed in his opening submission the two findings recorded against the appellant, holding her guilty of corrupt practices. Indeed, he was at a pain to convince me that his client had a strong prima facie case on the merit, in the sense that the judgment on its face was perverse and legally untenable. Although I listened at some length to these arguments and to an extent to the counter submission made by Sri Shanti Bhushan in his endeavor to establish that holdings were sound, I made it fairly clear in the course of hearing that at the stage when I was considering whether a stay should be granted or not, it was premature and perhaps unwise to pronounce on the merit of the appeal itself, except where judgment contained chronic errors, absurd conclusions, or glossy, erroneous propositions of law. Having considered the submission on this basis, I do not think I should express any opinion on way or the other on the merit of the findings. Nor do I regard it just for a counsel for the respondent to say that every discrepancy, that means discrimination, discrepancy means any lacking in the petitioner's evidence or other incorrectness in testimony can be called false. Not to accept a witness evidence may be due to many grounds of probability, not always because of university or unreliability. These aspects will surely be examined at the hearing of the appeal, not now. Next. Para 17. Sri Palkhiwala drew my attention to a few vintage instances of what he calls absolute stay, having been granted in election matters by higher courts. These are cases of a long ago, and argument based on them stems from an insufficient comprehension about the autonomy of the pre-1956 Representation of People Act, 1951 Act 43 of 1951. The code speaks for today based on a current practice and present law. 18. In this context, it is necessary to remember that in the Act as it is originally stood, election tribunal tried election dispute and election 107 provided. Section 107 provides election tribunals tried election dispute, and section 107 provided. What is given in 107? 107 orders to take effect only on publication and order of the tribunal under the section 98 or section 99 shall not take any effect until it is published in the Gazette of India under section 106. Indeed, there was no right of appeal provided in the Act, and the aggrieved parties had to approach the High Court or the Supreme Court under the provisions of the Constitution. The higher courts in such situations merely stayed the publication of the Gazette, the consequence being that the order of the tribunal did not come into the effect at all. The question, therefore, of an absolute stay or a qualified stay for the unsitting verdict did not and could not arise. To reply upon orders passed under the then law merely staying publication of the order of the tribunal in the Gazette as a tantamount to absolute stay of an order which took effect would be untenable. Then para 22, which is given on page number 11. Even on the basis of the post-1966 law, Sri Palkhiwala has argued that taking a legitimate cognizance of the peerless position of appellant as a prime minister of the country, judicial discretion must list disturb not merely her seat in parliament but her office in government. Para 23, I proceed to take a close-up of the sample orders made by this court during the last many years. Dissect them in a background of the judgments under appeal where such orders were passed and mouled by order deriving support therefrom. So I turn the focus on the implications and effect of a stay orders in the cases covered by Annexure A filed by the respondent, which are the consonance with the unusual orders passed by this court in election appeals. And friend, now I am going to conclude this case by reading 31 and 32, last paragraph. 31, what Justice Krishna Iyer is giving the final order in this matter. Let me sum up the terms of the operative order I hereby pass. 1. Subject to para 3 below, there will be a stay of the operation of the judgment and order of the High Court under appeal. 2. Consequently, the disqualification imposed upon the appellant as a statutory sequel under Section 8A of the Act and as a forming part of the judgment and order impugned will also suspended. That is to say, the petitioner will remain a member of Lok Sabha for all purposes except to the extent restricted by para 3 so long as the stay order lasts. What are the restrictions in para 3? That is important in representation of People's Act. And here para 3, they have given the restriction. What is the restriction? So para 3, which is stated by the Justice Krishna Iyer, the appellant petitioner, qua Lok Sabha member, will be entitled to sign the register kept in the house for the purposes and attend the session of Lok Sabha, but she will neither participate in the proceedings in the Lok Sabha nor vote nor draw remuneration in her capacity as a member of Lok Sabha. 4. Independently of the restrictions under para 3 of her membership of Lok Sabha, her rights as a prime minister or a minister, so long as she fills that office, to speak in and otherwise to take part in the proceedings of either House of Parliament or a joint sitting of the houses without right to vote, and to discharge other functions such as are laid down in Articles 74, 75, 76, 88, etc., or under any other law, and to draw her salary as a prime minister shall not be affected to detracted from on account of the conditions contained in this stay order. And para 32. This order by me sitting single as a vacation judge is being delivered with a sense of hurry, although after careful consideration of the argument had till last evening. So how much precautions Justice Krishna Iyer had took at that time. So friends, who are willing to become a judge of High Court or to become a judge of my Supreme Court, understand that while you are writing judgment, you should be a very diplomatic. So see the words again. This order by me sitting single as a vacation judge is being delivered with a sense of hurry, although after a careful consideration of argument had till last evening. Now the parliament is not in a session and the veto on the right to vote is currently academic. Situations may develop, circumstances may change, and this order itself, like any interlocutory order, is provisional. If new events like the convening of a parliament take place or fresh considerations crop up warranting the review of the restrictions in this stay order, the petitioner appellant will be at liberty to move a division bench of this court again to modify the restriction or pray for an unconditional stay. Likewise, the respondent may also, if justifying considerations appear anew more for variations of conditions in the stay order. How diplomatically Justice Krishna Iyer concluded this judgment. So, friends, to argue for the higher positions, persons like a prime minister is a great chance in the history. So, friends, this is our today's part 3. And in the next part, let me announce the next part will not happen on 4th, because on 4th there is a free legal guidance physical camp in Pune, which is happening at 4:30. From 4:30 onwards, today I have conducted press conference in Patrakar Bhavan. Press conference was conducted in a very nice way. I conducted in Marathi and some part in English. When asked questions in English and some asked me in Hindi, I explain in Hindi also. And just now, before one and a half hour, I completed that press conference and came to conduct this webinar. But during this, some journalists, some online news channel have already published that news also. So how efficient is the technology now? I'm conducting for Pune people physical online legal guidance camp on behalf of Nani Palkhiwala National Law Club. Yeah, you know, as a Supreme Court lawyer, we are charging consultancy fee 5,000 to 25,000. But on behalf of Nani Palkhiwala National Law Club, we are conducting such legal guidance camps free of cost. And this is my privilege. I can reach up to the bottom level litigants also through this. These camps are not giving me direct any benefit in my law firm, because I am handling matters of Supreme Court only. And all matters coming in Supreme Court after High Court, after Appellate Tribunal, no ground matter directly come to Supreme Court. But during this legal camps, I can interact with the district court litigants, tehsil court litigants, and I feel I am reaching to the bottom of the society also. This is a great privilege Lord Krishna is giving me through this Nani Palkhiwala National Law Club's activity. And on 5th January morning, I am taking the online free legal guidance camp. If you want to join, just keep eye on our Nani Palkhiwala official groups. You will get the link there of Zoom link. I will tell my PA Pooja to put the Zoom link on official group also of online legal camp. But this online legal camp was for Maharashtra people. So many people will discuss there in Marathi. So I have to discuss in Marathi, being a Marathi person. But some people will ask me in Hindi, I will give him, reply them in Hindi. And some people will ask me some questions in English. I will endeavor in giving my reply in English. And we will record that particular legal camp, and then we will upload it on YouTube channel. So friends, we will not conduct Nani Palkhiwala Jayanti series part 4 on 4th January at 4:30 p.m. Instead of that, we are conducting same part 4, which will be based on Minerva Mill case, which is one of the most landmark case of the land, in which Nani Palkhiwala argued very well and give a different turn to the legal history of India. And so that case we will discuss, instead of 4th January, we will discuss it on 5th January. Timing is same, 4:30 p.m. 4:30 p.m. we will discuss that case online. So we'll see you again in Nani Palkhiwala Jayanti series part 4 on 5th January at 4:30 p.m. Thank you very much for attending this session.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं, जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं, जो Amazon और फ्लिपकार्ट पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें, ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।